It all started with a tree. A damn tree. My neighbor's sycamore had been dying for years, shedding limbs the size of baseball bats during every storm. After the last branch punched a hole through my garage roof and came within inches of my workbench, I filed a civil suit. Not for much, just enough to cover the damage and some basic repairs. It should have been a straightforward case. I had photos, eyewitnesses, and even a city inspector's report confirming the tree's decay. The case was small claims at first, but once my neighbor, Ed, an ex-contractor with more pride than common sense, lawyered up, things started to spiral. His attorney, Glenn Whitaker, was known around the county as a courtroom shark with a wide smile and a reputation for playing dirty, just shy of getting disbarred. I didn't think much of it. I figured the truth would win out. It always does, right? That was my first mistake. From the moment Whitaker entered the scene, everything changed. Discovery deadlines shifted mysteriously. My repair estimates vanished from the official court record. The opposing side requested continuance after continuance, dragging what should have been a 2-week process into a 5-month war of attrition. Every court date felt like a performance, and Whitaker was the star actor, charming the judge, smirking at my frustration, spinning stories with just enough fact to sound plausible. Then came the day everything tilted. Whitaker presented a video supposedly captured from Ed's Ring camera. It showed me, yes, me, standing in Ed's backyard days before the storm, inspecting the tree, allegedly agreeing that it was my responsibility if the branch fell. The audio was grainy, full of digital skips, but you could just make out someone saying something that sort of sounded like me. The judge leaned in. My stomach dropped. It was a lie. I'd never been in Ed's backyard. I didn't even know he had a Ring camera. I protested immediately, demanding metadata from the file, but Whitaker waved it off, saying the video had already been verified by a digital technician. The judge nodded and moved on. Just like that, the truth became optional. I left that hearing shaking, angry, and scared. I wasn't just fighting a neighbor anymore. I was fighting a lie so well crafted, it almost convinced me I'd forgotten something. I knew I had to act, and fast. So I called my cousin Nate, a tech genius who now works for a cybersecurity firm. "Send me the video," he said. "Let's see what kind of magician we're dealing with." Nate analyzed the video within 48 hours and confirmed what I'd suspected. There were signs of editing and, worse, spliced audio. He found digital fingerprints, inconsistencies in the time code, and audio levels that suggested voice cloning had been used. "This isn't a video," Nate said. "It's a Frankenstein deepfake. Someone stitched it together from other clips. Your voice might be in there, but it's been manipulated to say something you didn't." I felt both vindicated and furious. I filed a motion to dismiss the video as evidence, citing Nate's report, but Whitaker came back with his own expert, someone with a long resume and a slick suit who claimed the video was 100% authentic. The judge decided it would remain admissible unless I had better proof. It was maddening. I was losing a fight against a fiction. That's when I remembered something crucial. Months before the suit, during a neighborhood BBQ, I had left my phone recording by accident while it was connected to a portable charger on the patio table. I'd hit record earlier that day while dictating notes and forgot to turn it off. It had captured hours of background noise, conversations, laughter, even me complaining about Ed's tree. On a whim, I scrolled back through that recording and struck gold. At one point, Ed mentioned that his tree was probably going to fall and that he wasn't going to pay a damn cent if it did. Even better, Whitaker had been there, drinking, laughing, and in one clear snippet, telling Ed to let it ride. If it breaks something, we'll flip the blame on him. I got tricks. My blood froze. I had it. Proof. They were planning the entire scheme months in advance. The quality wasn't perfect, but the voices were clear enough. I sent the audio to Nate, who cleaned it up, confirmed voice patterns, and matched them to known voice prints from Whitaker's court appearances. It was damning. But I knew just playing the audio in court wouldn't be enough. Not against a guy like Whitaker. I needed the judge to listen, really listen. So I filed an official complaint, attached the full cleaned-up audio file, and submitted a sworn affidavit from Nate outlining the forensic authenticity of the recording. I also made sure to notify the local press anonymously. If this thing was going to blow, it had to go nuclear. The court clerk scheduled an emergency hearing. Whitaker looked smug when he entered, until the audio started playing. The courtroom fell so quiet you could hear someone coughing 2 rooms away. When the line, "We'll flip the blame on him," hit, the judge leaned forward. When Whitaker's voice said, "I got tricks," the color drained from his face. He tried to object, claim it was doctored, but Nate was present via Zoom, calmly walking the court through his process, certification, and the digital signatures embedded in the audio. By the end, the judge didn't say a word. She just recessed the court for deliberation. I walked out knowing I'd turned the tide, but not without knowing Whitaker wouldn't go down quietly. The moment I walked out of that emergency hearing, the shift in energy was almost tangible. Where there had once been smug smirks and dismissive nods from Whitaker and his entourage, there was now silence, stiffness, and the faintest whiff of fear. I'd hit something raw, pierced the polished veneer of legal invincibility he'd worn like a badge since this circus began. But with the exposure came something else: retaliation. Within days, strange things started happening. My mailbox was tampered with. I received 3 calls in a row from blocked numbers where no one spoke, just breathed. Someone slashed one of my tires late at night. Then a complaint was filed against me with the local bar association claiming I had engaged in a pattern of deception and wire fraud, citing my use of the recording and accusing me of surreptitious surveillance. I wasn't even a lawyer, and the claims still triggered an investigation. Whitaker wasn't just panicking, he was reaching. But I wasn't rattled. I'd seen enough courtroom drama to know that when a guilty man starts flailing, it means you're getting close to the truth. I filed a police report documenting the vandalism and harassment. I installed cameras around my property, upgraded my phone's security settings, and kept a digital trail of every interaction, every document, every visit to court. Nate even set up a cloud sync system that uploaded my phone's recordings and messages in real time to a secure offsite server. "If they're going to come for you," he said, "they'll have to go through a firewall first." But even with the defenses up, I knew Whitaker wasn't done. He wasn't just trying to win the case anymore. He was trying to bury me. Then came the motion to dismiss. In a stunning display of arrogance, Whitaker submitted a petition to have the case thrown out entirely, claiming that my recording was illegally obtained and that I had created a false narrative through manipulation and forgery. He even had the audacity to attach a heavily redacted expert report that claimed my cousin Nate had ties to a known political activist group. It was laughable on its face, but dangerous in its implication. Whitaker was trying to poison the well, to make the judge doubt not just the evidence, but the integrity of the people behind it. And I knew if that poison stuck, even a whiff of impropriety could sink the case before the truth was ever fully aired. So I fought back. I subpoenaed the redacted expert and forced him to testify. Under oath, he admitted he had never examined the recording himself. His analysis had been based entirely on a copy provided by Whitaker, who had failed to disclose that it was already confirmed by a digital forensic specialist. Worse still, the so-called activist group, a nonprofit that advocated for public digital literacy and published open-source tools for audio verification. Not exactly the stuff of underground espionage. The judge's face hardened. She denied the motion to dismiss and publicly chastised Whitaker for wasting the court's time. "If you file one more baseless accusation without evidentiary support," she said, "I will hold you in contempt." Whitaker's mask cracked that day. He didn't yell. He didn't throw things. But his jaw twitched and his lips tightened into a line so thin it disappeared. I could see it. The fury of a man so used to being untouchable that the idea of consequences offended him. He wasn't just losing the case. He was losing the illusion that had kept him powerful. And with that illusion slipping, I knew he'd do something reckless. I just didn't know how soon. A week later, I received a package. No return address, just my name handwritten on the label. Inside was a USB drive in a single sheet of paper. For when it all falls apart. Suspicious as hell, right? I didn't even plug it in. I handed it off to Nate, who scanned it in a secure sandbox environment. What he found was unexpected. It was a folder containing raw footage from Whitaker's office security system. Someone, probably a disgruntled employee or maybe a panicked accomplice, had leaked the real smoking gun. The footage showed Whitaker in his office with Ed, preparing the ring footage. Not just reviewing it, creating it, on camera, using editing software, splicing clips together, playing samples of my voice through a modulator. At one point, Ed asked, "You think this'll work?" And Whitaker replied, "Doesn't matter. The judge will eat it up." I could barely breathe. This was it. Concrete, inarguable proof that the entire case had been built on manufactured lies. And even better, it showed Whitaker instructing Ed on how to respond if questioned, saying, "Just say he agreed to settle. If he pushes, we'll claim harassment." It wasn't just about faking evidence anymore. It was witness coaching, obstruction, and tampering all in one. Nate prepped the footage, watermarked it for chain of custody integrity, and we filed an emergency submission to the court with a motion to initiate criminal inquiry. This time, we didn't just notify the press. We called them. By the next morning, every local outlet was running variations of the same headline: "Attorney caught fabricating evidence in civil suit." At the next hearing, Whitaker showed up alone. No entourage, no flashy tie, no charm, just a red-eyed, sleep-deprived man with an open briefcase and a blank stare. The judge didn't even ask for opening remarks. She played the video. She paused it. She asked Whitaker directly, "Is this you?" He didn't answer. "Is this your office?" Still no answer. "Do you deny editing this footage?" Silence. The judge looked at the bailiff and said, "Escort Mr. Whitaker to the witness stand. He will be held for deposition under oath, effective immediately." The courtroom erupted, not in applause, but in sheer disbelief. People were stunned. The shark had been beached. That deposition lasted hours. Whitaker finally spoke, haltingly, nervously, with long silences and evasive glances. He denied at first, but the footage made denial impossible. Eventually, cornered by time-stamped edits and file logs, he admitted to minor adjustments for clarity and selective sound enhancement, both euphemisms for outright forgery. He tried to blame Ed, then tried to claim I had pushed him to desperation. But it was over. The damage was done. The judge suspended the civil proceedings and referred the matter to the district attorney for potential criminal charges. She also ordered restitution be calculated not only for my property damage, but for emotional distress, defamation, and legal sabotage. It was the beginning of Whitaker's end, and he knew it. The week after the emergency deposition was like standing in the eye of a hurricane. Everything was technically quiet, but I could feel the pressure all around me, emails stacking up, reporters calling, and a growing parade of strangers stopping me at the grocery store with looks of either admiration or thinly veiled curiosity. I hadn't asked to be famous, but in our little town, I was now the guy who brought down Glenn Whitaker, the man who exposed one of the most feared lawyers in the county for what he really was. A fraud wrapped in a pinstripe suit. What should have ended with one repaired garage had become a wildfire, and it was now burning through the entire legal community. Within 3 days, the State Bar Association launched a formal ethics investigation into Whitaker's conduct. By the end of the week, they placed him on interim suspension. A special investigator was appointed, and depositions began rolling in, not just from my case, but from other clients, former paralegals, and even a few anonymous attorneys. One former secretary came forward with a sworn statement detailing years of doctored affidavits, destroyed records, and even ghost-written witness statements created in-house and signed under duress. The floodgates had opened. What started as a tree branch through my garage had turned into a Class 5 systemic breach. Whitaker, to no one's surprise, refused to go quietly. He filed a civil countersuit against me for defamation and deliberate sabotage of professional reputation. His argument? That I had hacked into his private security system and illegally obtained footage. I almost laughed when I read the motion. Even the judge didn't hide her disdain. She dismissed it on the spot and ordered Whitaker to pay my legal fees for responding. But it didn't stop him from trying to weaponize the court of public opinion. He released a video online, just him, speaking directly to the camera, saying he had always fought for the underdog and was being targeted by a smear campaign. The comments didn't go the way he'd hoped. "Where's the deep fake now, Glenn?" Someone posted. Another said, "You're not the underdog. You're the fraud." Despite everything, I didn't feel triumphant. I felt tired, exhausted really. The emotional toll of the case had caught up to me. I hadn't slept through a full night in months. I kept expecting the other shoe to drop. That somehow someone would find a loophole, a technicality, a back door that would unravel everything I'd built. Nate noticed. "You're twitching in your sleep," he told me. "You grind your teeth when you're stressed. You've got to start thinking about life after this." And he was right. But before I could even breathe, the DA's office called. They wanted me to testify. It wasn't a trial yet, just the preliminary phase of what could become a full criminal case. They wanted to establish a record of how the fabricated evidence was created, introduced, and challenged. I agreed, of course, not just because I wanted justice, but because I owed it to every person who'd ever been steamrolled by someone with more money, more experience, and fewer ethics. My statement took 2 hours. I walked them through every detail: the tree, the first court filing, the fake ring footage, the secret recording, the retaliatory tactics. By the end, the investigator just shook his head and said, "This guy was a machine. No wonder he never lost." Meanwhile, Ed, the neighbor who started this whole mess, finally broke his silence. His own attorney dropped him, citing irreconcilable trust issues, and he was left to fend for himself. He called me one night, voice trembling. "I didn't think it would go this far," he said. "I thought it was just going to be a quick trick to shut you up." I didn't yell. I didn't curse him out. I just listened. And then I told him the truth. "You could have just paid for the damn garage." He offered to settle. I declined. It wasn't about the money anymore. It was about the principle. We'd gone too far for handshakes and apologies. The justice system needed to do its job now. Public sentiment kept building. Local news ran nightly updates on the case. One station even dug up an old segment from 5 years prior where Whitaker had been caught in a minor ethical skirmish involving fabricated expense reports. At the time, it was dismissed as a clerical oversight. In hindsight, it looked more like foreshadowing. Law forums exploded with debates. Was this an isolated incident? How many other attorneys had skirted the edges of legality with similar tactics? Were digital forensics going to become the new battleground for civil litigation? I was quoted in one article saying, "Truth doesn't fear scrutiny, only lies do." It went semi-viral. The court scheduled a restitution hearing. Judge Marlowe, who'd taken over after the initial judge recused herself, reviewed the updated damages report. It included not just the cost to repair my garage, but also legal fees, digital forensics, security upgrades, emotional distress, and reputational harm. The total? $142,870. Ed paled when he heard it. Whitaker didn't even show. He sent a stand-in with a note saying he was seeking treatment for stress-related illness. Marlowe ordered a lien placed on Whitaker's personal property, including his second home and 2 vehicles, to ensure restitution could be collected if damages were awarded in my favor. Still, there was no verdict yet. The criminal charges were pending, and my civil suit, now merged with multiple other cases, was part of an ongoing investigation. But something had changed. I wasn't alone anymore. People were watching, whistleblowers were speaking. One junior associate who had trained under Whitaker wrote me a letter. "I used to think I had to play the game to survive," he wrote. "You proved the game can be beaten." I pinned it to my fridge. Then came the biggest shock of all, an email from a major legal ethics nonprofit. They wanted me to speak at their upcoming summit, not as a victim, but as a case study. "You represent what happens when a civilian refuses to back down," the organizer wrote. I accepted, not because I wanted to be in the spotlight, but because if someone like me, just a guy trying to get his roof fixed, could take down someone like Whitaker, then maybe the rest of the system could start cleaning itself up too. But the storm hadn't passed, not completely. I knew Whitaker still had connections. I knew trials could turn. But for the first time since this mess began, I felt momentum shift, not just in my favor, but in favor of truth itself. Because when you expose the rot, you don't just remove the infected limb. You force everyone else to check their roots. By the time the official criminal trial date was announced, the buzz had died down a little, but not by much. The court's docket posted State versus Glenn Whitaker in bold black font, and beneath it, the charges: obstruction of justice, evidence tampering, perjury, and conspiracy to commit fraud. 4 felonies. It was surreal. For a while, I kept checking the case file online just to confirm it was real. It felt too cinematic, too big to belong to someone like me. But there it was, official and irreversible. The trial would be open to the public. I wouldn't just be a witness, I'd be the first one called. The prosecution labeled me Victim A in the indictment, and though I flinched at the term at first, I had to accept that's what I'd become. Not because I lost something, I hadn't, not really, but because I'd been targeted, manipulated, and nearly destroyed for daring to demand the truth. The courthouse was packed on the first day. More reporters than seats, more whispers than silence. Whitaker entered flanked by 2 high-priced attorneys, new ones, flown in from out of state. They wore matching charcoal suits and talked fast. Their defense was simple. Whitaker had made mistakes, yes, but none that warranted prison time. This is a matter of professional misconduct, they argued, not criminal intent. It was like watching someone try to call a fire a warm breeze. The prosecution wasn't having it. Their opening statement was surgical. This man didn't just fake a video, the DA said. He engineered an alternate reality, fed it to the court, and almost got away with it, until the tape played back. When I took the stand, the room shifted. I could feel the weight of 100 eyes pressing on me, waiting for me to flinch. I didn't. I swore in, sat up straight, and began from the beginning. Again, the neighbor's tree, the faked footage, the accidental recording, the tampered evidence, my cousin's forensic work, the USB drive, the second recording, the video files, every twist, every tactic. I laid it all out like a map drawn in blood, voice steady, hands clasped, binder thick with exhibits. The jury didn't blink. When the prosecution queued up the office footage of Whitaker fabricating the ring video, the entire room held its breath. The screen flickered, and there it was. Whitaker hunched at his desk, audio looping, waveform graphs on his monitor, coaching Ed like a sleazy director shaping a lie. The cross-examination was predictable. The defense tried to rattle me. "You're not a lawyer, correct?" they asked. "No," I said. "But you decided to launch a digital investigation anyway?" "When someone lies about you in court," I replied, "you don't need a law degree to find the truth. Just a backbone and a good tech guy." There were a few suppressed chuckles from the gallery. Even the judge smiled faintly. The defense pressed on, trying to poke holes in my cousin Nate's credibility, his tech company's licensing, the chain of custody, but every answer was clean. Every process documented, every transfer logged. We were ready. I wasn't just defending myself anymore. I was defending the process that had uncovered the truth. Other witnesses followed. Ed, sheepish and cornered, testified under a plea deal. He admitted to following Whitaker's advice, parroting the lie in hopes of dodging responsibility. His voice cracked when he said, "I just didn't want to pay for the roof. I thought it'd be cheaper to make it his fault." A former paralegal described how Whitaker kept templates of fake affidavits on his desktop, ready to plug and play. An IT contractor revealed that Whitaker had tried to hire him to scrub the office server, an offer that was rejected and smartly documented. Piece by piece, the puzzle reassembled itself in front of the jury. And at the center was Whitaker, calm, quiet, face unreadable, as if he were watching his own obituary being written in legalese. Then came the secret weapon, the playback. Nate had reconstructed a side-by-side video overlay showing the ring footage and the original clips it was spliced from. It was devastating, like watching a magic trick in reverse. The jury saw how my voice was taken from an old voicemail, how the visual of me walking across the street had been flipped and darkened to look like I was in Ed's backyard, how even the timestamp had been forged using open-source metadata software. "This wasn't a mistake," the prosecutor said. "It was a masterpiece of manipulation. But the thing about manipulation? Eventually, the string gets tangled. The defense barely put up a fight in their closing arguments. They tried to pivot. Mr. Whitaker has served this community for 20 years, they said. He made an error in judgment under pressure. But the jury didn't buy it. The verdict came back after only 4 hours. Guilty on all counts. The courtroom buzzed, not with celebration, but with catharsis. Justice had spoken. The judge ordered Whitaker into immediate custody pending sentencing and recommended permanent disbarment. He was led away in cuffs, head low, no longer the predator in a suit, but just another man who thought he was too clever to ever get caught. After court, I stepped outside into the flashing lights of a dozen cameras. I didn't give a speech. I didn't need to. I just looked into the lens of the nearest reporter's camera and said, "Let this be a message. The truth always plays back." Then I turned and walked to my car. Alone. Free. The sentencing would come later, but the real judgment had already landed. Not just on Whitaker, but on a system that had let him operate for years. Already reform petitions were circulating. Other attorneys were quietly resigning or reassessing their strategies. And people who had once felt powerless were speaking up. If truth is a light, then this case had cracked open the shutters. The courthouse felt colder on sentencing day. Not in temperature, but in atmosphere. Like the walls themselves had taken a deep breath and were holding it, waiting to exhale. The crowd outside was smaller than at trial, but more intense. Not curious rubberneckers, but people who had followed the case from the beginning, victims of similar legal manipulation, a few lawyers looking pale under their ties. I arrived early wearing the same suit I'd worn to the verdict, not out of superstition, but out of respect. This wasn't about victory anymore. It was about consequences. Real ones. The kind that write themselves into the footnotes of a broken system's history. Whitaker was already there when I entered. Cuffed, flanked by 2 bailiffs, his once pristine hair now graying and unkempt. He looked smaller. Not in size, but in presence. Like someone had finally turned off the spotlight he used to carry around in his smile. He didn't look at me. Didn't look at anyone, really. His attorneys sat beside him, whispering quickly, pointing at papers. But no one looked hopeful, because today they weren't defending him. They were just asking for mercy. The judge began by recounting the charges and reviewing the trial's facts. It was surreal hearing my name and my cousins mentioned so often, almost academically. The defendant engaged in a premeditated act of evidence tampering, she said, and did so with full knowledge of the consequences and intent to deceive this court, harm the plaintiff, and obstruct the course of justice. She paused, looked at Whitaker. "You were an officer of this court. Your duty was to protect truth, not reinvent it. And yet you did more than lie. You engineered a false reality and tried to sell it as fact." The prosecution requested the maximum penalty allowed under the law, 10 years in prison, citing aggravated circumstances, repeated patterns of misconduct, and the extensive damage done to public trust. The defense, as expected, asked for leniency. They played the family man card, the moment of desperation card, the long career of public service card. I'd heard it all before. So had the judge. She nodded slowly, as if each word of their plea was a stone tossed into still water. When they finished, she looked up and called me to the stand. I hadn't expected to speak. I didn't even have notes. But I walked up anyway and said the only thing that mattered. This wasn't a misunderstanding. This wasn't a moment of weakness. This was war, and I didn't start it. I just refused to lose it. I told them how close I'd come to giving up, how Whitaker's tactics nearly broke me, financially, mentally, even physically. How many nights I sat with my laptop open at 3 a.m., replaying fake footage of myself, trying to convince myself it wasn't real. He didn't just tamper with evidence, I said. He tampered with my sense of reality, and that should scare everyone in this courtroom. The judge thanked me. Then she passed sentence. "Glenn Whitaker, you are hereby sentenced to 7 years in state prison with eligibility for parole after 5. You are ordered to pay restitution in the amount of $148,930 to Mr. Sean, and will be permanently disbarred from practicing law in this or any other state." She banged the gavel once, sharp, Final, like the slamming of a cell door. Whitaker didn't react. He just stared ahead, like a man whose entire world had been dismantled one brick at a time, until all that remained was a courtroom and a sentence. But sentencing was only the beginning of the next collapse. With Whitaker out of commission, a chain reaction ignited. Clients from past cases came forward. Some claimed he'd doctored discovery responses. Others said he'd pressured witnesses. A few even suspected he'd fabricated emails and backdated documents in prior civil disputes. The state bar reopened 5 cases, then 10, then more than 30. One particularly tragic story surfaced. An elderly woman who had lost custody of her home after a ruling swayed by Whitaker's misleading documentation. Her son wrote to me, "You did what we couldn't. Thank you for turning the tide." The media coverage hit new highs. News outlets coined it the Whitaker wreckage. Legal podcasts picked apart every motion, deposition, and audio file. I was invited to speak at legal roundtables, educational panels, even a symposium on digital truth in the age of AI. Nate and I co-authored a journal article titled "Digital Footprints in Legal Forensics When Truth Fights Back." I never imagined my cousin's tech hobby would one day help convict a high-profile lawyer, and neither did he. But there we were, 2 nobodies from a cul-de-sac, changing the game from inside a courtroom. Meanwhile, reforms began to circulate. 2 state senators introduced the Transparency in Trial Act, mandating third-party verification of all digital evidence in civil and criminal courtrooms. A coalition of civil rights groups launched the Playback Initiative, pushing for better access to forensic tools for plaintiffs without deep pockets. It wasn't enough, not yet, but it was a start. And it all started because one man tried to fake a win and got outmaneuvered by a recording he didn't know existed. As for me, I tried to return to normal. I rebuilt the garage, replaced the roof, restored the fence between my yard and Ed's, not because I had to, but because closure needs boundaries. Ed moved a few months later, quietly. I didn't say goodbye. He didn't wave. But I saw the moving truck pull out of his driveway and felt something in my chest finally let go. One night, months later, I found myself rewatching the court playback, not out of vanity, but out of disbelief, that it really happened, that justice wasn't a myth, that sometimes the little guy doesn't just survive the storm, he sets it on fire. I closed the video, turned off the lights, and stared out at my backyard. The tree was gone now, the hole in the roof patched. But the fight it started, that would be remembered. The headlines eventually faded. As the weeks wore on, the public's appetite for the Whitaker scandal dulled like any